day to all the viewers at home, and welcome to the program called A New Thing, brought to you by the Global Business Roundtable. My name is Sipho Mseleku, the convener of the Global Business Roundtable, and I'm your host for this program. Now I'm going to introduce our panelists for today's program, which focuses on wills and estates, how we can use wills and estates as effective tools for estate planning. It's important to plan for your loved ones. It's important to know that we are all mortal, that we will die one day, and what we do whilst we're still alive can have an impact and influence our loved ones when we are gone. I will start introducing from my right-hand hand. I have Mr. Leon Jacobs. He's a legal manager at Standard Trust Limited. And on my left is Mr. Thabiso, head of beneficiary funds at Standard Trust Limited. On my extreme left is Mr. Alex Simeonides. He's a chief operations officer at Capital Legacy. Welcome, gentlemen, to our show. Let's just start by getting your introduction, and you tell us more about who you are, your background, and where you work, and your experience, for the past few years.
Thank you very much. Yes, I'm a lawyer. I've been in private practice for the last 5 years, specializing in wills, trusts, and estates. Recently joined the team at Standard Trust Limited, which is a part of Standard Bank. And yeah, I'm from Namibia originally, and I've now recently relocated to Johannesburg.
Welcome.
Thank you.
It's great to know you.
Thank you. My name is Thabiso. I'm an admitted attorney. I have been practicing as such since 2002. In the past, I've joined Liberty as the regional legal advisor. Currently, I'm with Standard Trust as the head of beneficiary funds.
Thank you very much. Alex?
Thank you. Yes, my name's Alex. I'm South African. I head up the operations of Capital Legacy, a South African-based wills company. My background is a financial planner, previously with Liberty and Discovery. My role is to make sure that our estates are wound up and that our wills are done correctly so that we can deliver a quality estate to the beneficiaries.
Thank you very much. Now you've heard the background of our panelists. We're going to get straight into it. What is a will? What is a trust? Why do we need wills? And what's the difference between the two, wills and trust? And what's the difference between inter vivos trust and testamentary trusts? Let's just still start with introductions of the subject matter that what we're going to talk about. Who wants to start?
Well, shall I start?
Okay.
Yes. In South Africa, we've got a principle called the freedom of testation. That essentially means that when you die, when you pass away, you have the right to determine who inherits your assets. That process gets actually done in your will. So that's a document where you dictate what happens to your assets after you've passed away. Essentially, it's your voice after death.
It's your voice after death. So if you don't have a will, it means what? That you have no voice. A decision can be made for you.
Yes, that's correct. If you don't have a valid will, the law will determine how your estates gets distributed. So you are essentially bound to what an act says. The act's name is the Intestate Succession Act, and that gets forced upon you.
Okay, I'm sure we've heard that. Do you want to add?
Certainly. The will is one of those most important documents that you can ever sign during your lifetime. It will incorporate a testamentary trust for your minor beneficiaries, children, or those people who depended on you. So it is such an important document. Unfortunately, a lot of people tend to ignore doing one, or they always postpone doing a will. So I would encourage everyone out there to do a will as soon as possible.
So we've heard from the two panelists the importance of the will, just as a starting point, that if you die without a will, the law will make a decision on how your estate is distributed. In other words, you no longer have any power even if the people you wanted included in the will may not be included because you didn't say so. So you're taking a risk of somebody else determining how your estate is distributed. I think that's the essence of it.
100%.
And how your children are treated. And some of the people may be excluded that you may wanted to be included. And some of the people that you wanted excluded may be included by the law, which is called the Interstate Succession Act. And I think that's very, very important. Do you want to add something there, Alex?
Sure. Well, let's unpack your question. What is the difference between a will and a trust? So often the two words are put together, and quite possibly that causes confusion for people. The way I try explain it to beneficiaries as well as people do in their will is that first understand that a trust is a separate legal entity, whereas your will deals with the things that you own, be it your watch, be it the money in your bank accounts. Your will can create a trust, however, a separate legal entity, to put the money in your bank account into a trust for the benefit of those that you want to have enjoy the benefits of your money.
That's when you're speaking about the difference between inter vivos trust and the testamentary trust. Can you explain that to the viewers?
Correct. So the simplest way to understand the difference between a testamentary trust and an inter vivos trust is that an inter vivos trust is something that you create now while you're alive. It's a living, breathing entity that's created by a document that you will draft in consultation with a specialist. And it needs to be looked after. A testamentary trust is something that doesn't exist while you are alive, but it is created in terms of the will that you document, again with a specialist or a consultant. So the difference really is that the one is now while I am alive, and the other when I am deceased.
I think that's very important. Many people have what we call family trusts. And those family trusts, and sometimes business trusts, those family trusts are created during the lifetime of a person. This is when a person takes some of his estates and put them in a trust. And that trust is a separate legal entity and from you. In other words, the assets of the trust belong to the trust, your assets belong to you. And you can be bankrupt, but a trust can, and its assets can be attached. Your asset can be attached, but because the trust is a separate entity, its asset will remain untouched. So I think that's because it's a different person in law. So it's like a company, which is a corporate entity, which is a different person in law. I think that's what Alex is trying to explain. But the clarity on the separate trust, the testamentary trust, in other words, the trust that come into effect with when you die. In other words, testamentary trust is a trust that does not exist until you die. It come into effect. It's incorporated by a will. That's what you're saying.
Well, maybe we could understand the difference from their purpose.
Yes.
And their commonly used purpose, because they can both be used for the same purpose. So commonly, a testamentary trust I would use if I have a minor child, a child that is under the age of 18 here in South Africa, and I want that child or my children to inherit. Now, because of their age, they cannot manage their financial affairs. And so in my will, I say to my executors to go and create a trust, and I appoint responsible, knowledgeable people as trustees to look after the money within the trust for the benefit of my children.
Exactly.
Now, I can use an inter vivos trust now while I'm alive to do that, but there is a cost and a complication to do it, and maybe it's not worth my while. It depends on my individual circumstances, so a testamentary trust would be more applicable.
Okay. A few questions I have is, what happens to your assets when you die? And especially when you die without a will, how are they distributed? Can you write a will anyhow, or do you need an expert to advise you on writing a will? Once your will is written, what happens if your circumstances change? Do you have the right to change it? And what do you do if you want to change your will? And how are these assets distributed to your beneficiaries if you die without a will? And what happens to your minor children? and adoptive children and other people. And how does the administration of the estate work? You know, and how long does it take to wind up an estate? And I think these are the kinds of things. And how is this estate distributed to different parties, including the SARS, the commissioner, the revenue, the receiver of revenue? So if you can each deal with those aspects in this part, it would be grateful. Who want to start?
Shall I start with the estate?
Okay.
So the first part of your question is what happens to your assets when you pass away? If you pass away, somebody must be appointed to look after and administer your estate. That means to take control and custody of the assets that you leave behind, pay the debts that that needs to be paid, and then distribute it either according to the provisions of your will or in accordance with, in South Africa, your Intestate Succession Act. So first step is to have that person appointed. Now again, this is a person that you can nominate. You've got the right to nominate that person in your will. So again, there it's important to draft that will to make sure that you exercise control over that, because it's a very important job. Then another aspect, then once the executor has been appointed, he then administers the estate, which is quite a complicated procedure and a formal procedure. And after that, he will distribute it to your nominated heirs or the heirs determined by the Intestate Succession Act. A further aspect that's quite important in your will is the nomination of guardians. Those are the people that would look after your children if you leave behind minor children. So again, the importance of a will cannot be overstated.
Yeah.
You work hard during the course of your lifetime to build up an estate, and a document like this ensures that your legacy gets carried forward.
The way you planned it, the way you want it.
Correct.
Great. Sir.
If I can add on to that, what happens when you die without a will? In South Africa, there's a law that stipulates what exactly must happen. By way of an example, if two parents die, both of them in the same car crash, everything will go down to their children equally. So those are some of the things that the parents may not have wanted to do. There could be a physically disabled child that they needed or they planned to give more because other children are older, they are able to work for themselves, etc., etc. Those are some of the challenges that that will happen. Two, when you die without a will, the other problem that happens is that the state will nominate the executor for you. The executor being the person who winds up the estate for you. This person does not know your children. He does not know their needs. The guardian, the family will decide who must be the guardian of your minor children. Could be the person with different beliefs than the parent of the. So those are some of the things that people need to take into account. When you die without a will, chances are that you may not have made provision for your financial circumstances. What do I mean by that? You could have a bond that is outstanding, say a Standard Bank. Have you made provision for that bond? What's going to happen to other creditors that you left behind? They need to be paid, but you did not make provision. You did not sit down with your financial advisor to specify exactly what cover do you need. So those are some of the problems that people are facing out there.
So it's very important for people to, whilst they're still alive, to consult with their financial advisors, legal advisors, to help them, advise them in putting these things together.
It is absolutely important. All the trust companies out there, they are facing the problem of insolvency in their estates. People are dying without life policies paying to their estates, which makes it difficult to wind up the whole process. I'm sure Alex will elaborate
more into that. But I've read in one of the newspapers about many policies that remain unclaimed. The beneficiaries out there and that are not known because probably their parents did not disclose that they've taken policies for the benefit of those people. So we'll come back to that later.
Okay.
Alex.
So to continue the thrust of what my colleagues here have been saying is that it's important to have a will. So the next step is to take action. A will is probably the most often procrastinated upon task in our population. So you can go out and you can go and see a lawyer, a trust company, You can even go and get something from a bookstore, download from the internet, a template will. Now, not to detract from just doing something to get a will done, our experience has been that you should ideally consult with someone that is knowledgeable. One doesn't self-diagnose their illness. They'll go to see a doctor so they can make sure that they get the right medicine to get better quicker. And the same applies when confronted with, I want to do my will now, let me do something myself on the back of a napkin at a restaurant, which are valid. We've used them before, from what we call a template will. But again, I encourage you probably would not have thought of everything that would be applicable to your situation. And that is why our economy provides us with experts. You must use them when you're doing a will. So to recap very quickly, there are many ways now, if you want to do a will, to do. You can go onto the internet, you can go to a bookstore, but I would encourage one to seek out consultation, be it with friends, with a colleague, with a specialist.
It's always advisable to use a specialist. People are knowledgeable.
Yeah,
Because,
if I could also, sorry.
Yeah, sure.
If I could add to what Alex is saying, another aspect to be cognizant of is that there's formalities that pertain to drafting and executing a valid will.
Yes, exactly.
So you have to make sure that you comply with those formalities. For example, 2 witnesses need to witness you signing it. It needs to be properly dated.
And there are people who can be disqualified from inheriting.
Correct.
From the will.
Correct.
And if they've witnessed.
Yes.
Some of them. There's a category of people who get disqualified.
And
so there are those things.
Yeah.
Well, an example is a current estate we're dealing with, and a very specific amendment was made to their own will that they had drafted in handwriting, and it wasn't properly witnessed or initialed by the person making the will, and that clause has been discarded by, in our country, the master of the court, so it's not applicable.
Yeah.
Because it was not done in consultation. A specialist or a competent person would have said, you need to sign here, or let's maybe redraft it.
It's always important to advise, I think, to get advice, legal advice, special advice, to ensure that that will is valid. Because the worst thing that can happen is come the time when your estate has to be distributed, people bring the will and the court says your will is not valid. But the issue of procrastination, why do people struggle to write their will in time? And we do all kinds of things, do complicated stuff in our life, but we just can't get to doing our wills. Is it fear of death, or we never just think about it?
Fear of death is absolutely one. Potentially the perceived cost of doing the will is another. I also think people think that they are immortal and that they've got enough time on earth that they don't need to do it today. And boop, it happens tomorrow.
Another thing, when you're doing a will, you're talking about death. A lot of people do not want to talk about death. They do not want to think of the day they will leave this earth. Unfortunately, it does happen. In some instances, it's cultural beliefs. If you're talking about death, it's going to happen.
It's a taboo. It's going to happen if you talk about
Correct.
it. Okay.
In some instances, the 2 parties cannot agree. Mom has got children from a previous marriage. So is that. So they cannot agree. So they keep on postponing until, unfortunately, death occurs.
And then things get even more complicated.
Absolutely.
When you just suddenly leave and you've not solved your problems. And they fall in other people's hands.
Yeah, just to add what my colleagues have said, it's also, if you don't take the time to draft the will while you're alive, then it complicates the administration of your estate after you've died, and it's undue hardship on your heirs and your family, because the process gets drawn out. It takes longer for them to actually benefit from the assets that you've left to them. So it's not a complicated procedure, and it's really something that I would advise everyone to do.
Can we just now deal with the trusts? Why do we need trusts? And how is it better than a will? For instance, testamentary trust versus inter vivos trust versus testamentary trust. Why do we need that? And what are the benefits of doing that, if there are any? Tax benefits, practical benefits when you passed away, and all those kinds of things. And how are these trusts set up? and who can set them up, and what is your advice to people to do in terms of registering these trusts? And is it advisable for people to hold their assets in their name or to put them in a trust? And what is more beneficial to them? Can we talk about that? Who want to start? Leon.
Shall I start?
Okay.
Yes. Trusts is a very complicated topic, and I guess I would start by saying that it's case specific. So there's no general rule saying that everyone should have a trust. It's really, you need someone to advise you properly on your estate and the assets that you have and the best way of dealing with it. The one thing that we must be cognizant of is that a trust doesn't die. So a trust can theoretically go on in perpetuity. And one of the key benefits of a trust is that once you've moved assets into that trust, there's no need for it to pass over to another person, because every time an asset passes, it may trigger tax.
Yeah, transfer duty and...
I would say that would be an advantage of it. Another thing about a trust that I also want to emphasize is that it really goes around the separation of control over an asset and the benefit of an asset. So you may have a situation where a party does not necessarily trust his family members to use those assets wisely, so he gives the control of those assets to a trustee to administer to the benefit of a family member or a beneficiary. And so that's also where testamentary trusts comes in. So when you have a minor child, that child cannot necessarily administer those assets. In fact, the law doesn't allow him to. So the trust is there to protect those assets for a certain period of time until that person is able to administer the asset on their own.
Yeah, we've seen many people who received huge inheritance from their parents, millions and millions of rands of dollars, and they blow everything away within a year.
Correct.
And because their parents did not plan on how these assets should be utilized. So,
One of the reasons why people need a trust is for the protection of their assets. You've got a farm that you would like to keep within the family. You've got a holiday home that you would like to keep within the family, enjoyed by generations and generations. Those are some of the reasons why you would put the assets into a trust. For tax purposes, when a person dies with an estate above 3.5 million rands, there's estate duty that is payable. If your assets are in the trust, there's that protection. So it's always going to be various reasons why you need a trust. As my colleague has indicated, you've got a mentally disabled child. You will protect his or her assets in the trust until death occurs. Your children, when they marry, if the assets belong to the trust, they will marry outside of the trust without including the assets that are in the trust. So there's various reasons.
So the assets in the trust do not become part of the income unit of property when they get married?
Because the trust is a separate entity from you.
Okay, it's not a person, it's a separate entity.
The problem is with trusts is that they are poorly advised on and poorly operated, and that can create a much worse problem than not having a trust. Because, for example, I create a trust, and Leon mentioned it, that there needs to be independence where you're exercising control of the assets for the benefit of the beneficiaries. Now, what I mean by that is you need 3 people, for example, here in South Africa. One needs to be completely independent of you. That doesn't mean your auntie or your uncle or even your business partner. And if you don't get that right, then the tax benefits that Leon mentioned fall away. Because our revenue service, for example, here in South Africa and in many other countries will say, that trust is a sham. So you've done all your planning, assuming there is no tax bill, and you didn't do things properly, and now there's a tax bill. And disaster strikes because a house may need to be sold, maybe even the holiday home.
So it's very important the structure is as important as the content in the trust, the provisions of your trust. But there's a point that you said, which is very important for me, and I think for the viewers at home, the fact that trust is a separate person in law. It's a juristic person. It does not die. And therefore, when a founder of a trust dies, the estate does not need to be wound up. You simply replace the dead trustee with somebody else. The remaining trustees can appoint, or even the trust itself can say who should be appointed, who should appoint the next trustee. So there's no disorganization in terms of the way your children live and your family live when you pass on. I think that's a convenience that you find for your trust.
The thing I've always encouraged with my past clients is often I get to individuals that are later on in their careers and they've accumulated wealth in their estate. And it's a story of should have, would have, could have with regards to creating a trust, maybe to own the shares in the company they started 20 years ago. So the advice I always try and encourage people is do it early. If you're going to do a trust, do it early. Do it when you're starting a business, when you're thinking about buying that home. Whenever you're going to be doing a significant purchase or build, question whether a trust is necessary. Because once you've started that business and it's grown in value, it's very difficult now to get that into the trust.
Is it because of tax, transfer duty?
Taxes, transfer costs themselves, the fact that you'll always be then, you could sell it to the trust, but you'll always be sitting with an asset in your estate because the trust owes you money for that.
Exactly. Okay.
Just to elaborate on a legal technical aspect, the trust is from a legal perspective not really a person or like a company, for example. A trustee gets appointed and the assets actually vest in the trustee.
Yes.
So whilst it actually has the effect of a legal person, in law it's actually not.
Yes, but it's always regarded as separate.
It's regarded as separate. That's correct.
So it's a separation of personalities that Sipho Mseleku, myself, and Sipho Mseleku Trust in law are two different entities.
You're right. And just to elaborate on Alex's point, how important it is to appoint an independent trustee.
Yes.
Because those assets vest in that trustee.
Yes.
So he's wearing a trust hat, and it becomes very important that that person administers it properly.
No, is this the inter vivos trust or the testamentary trust?
It's both. Both.
But in terms of the testamentary inter vivos trust, you may have more trustees, not one.
Correct. Usually, we at Standard Trust feel that you'd at least have 3 trustees, 2 trustees from your family and 1 independent trustee. It really depends on the circumstances, but that's usually the safest route.
Yeah.
So you've got that personal input from the family as to how they want to administer their the trust assets, but you've also got that independence to make sure that what Alex has referred to as a sham trust situation does not occur.
It's very important to have an independent trustee. One point you want to mention, and then we'll go to a break.
Often people approach a trust and they're thinking that they're going to just open a company to own a property. That still doesn't create the separation of that entity that can continue the ownership of that asset. So I just warn the viewers at home that having a company own an asset is different to a trust bestowed with the asset.
We are talking about wills and trusts as an effective tool for estate planning. Our panelists are busy giving us practical advice on how we can navigate and ensure that our loved ones are protected when we've moved on. Now, let's continue where we left off about the benefits of the trusts, the benefits of the wills, and why it's important that you are always in control. And in actual fact, there's a belief that many people are worth more when they die than when they are alive, because that's when your pensions are forced to be cashed in, your provident fund, your investments, all kinds of things, your insurance, they pay out. And that's when it becomes even very important that you make proper decision when you put these instruments in place. And what are the practical steps that you can give to the viewers at home to plan their affairs? Let me start with you.
All right. The first thing that I would advise the viewers at home is to have a broker or what is called a financial advisor. These are found in banks. You go to any standard bank, there will be a department that's dealing with all the financial planning matters. This is the person who's going to tell you how much you will need in the event of death, what are your taxes like, retirement planning, basically all the things that you will be surprised of at a later stage. This is the person who will take you through your life stages. At the beginning of your life, what do you need to do? Later on in life, what do you need to do? These are the things that will be incorporated, including your will. A trust advice, if there's any. By the way, I wanted to mention earlier on that a trust, unlike a will, it's not something that you can do yourself. You need to consult
Definitely.
with an expert. You need, your reasons for doing the trust must be legal. I've heard people wanting to set up a trust quickly to hide their assets. It does not work like that. So those are some of the advice that I would give. Go talk to a specialist who will give you the right advice.
I agree. Always it's important to seek advice. They say it will cost you more later if you try to do yourself something that you can't do, that you cannot advise yourself. Get a lawyer, get an accountant. There are financial institutions there that can help you give right advice for you for a right decision. I think I agree with you. Experts are important.
So your question was, or point that you raised, being worth more dead than alive. And from the face of it, yes, that is true, because a life cover and a pension fund can now vest in the hands of your family. But one must remember that the person that was making all the money is no longer here. And those assets are there to replace the loss of that income earning ability in the household. And things like a will and a trust control how those assets are managed and are used to now effectively supplement or replace that income that has now been lost from the person that has been removed from the family. So I wouldn't say people are richer dead, because you must always factor in that loss of the income.
You're right, actually, because your responsibility as a parent continues even if you're gone. So, and it's how you've provided for it through proper planning that your children are able to be taken care of when you are gone. I like that point.
Yes, for me, it's about leaving a legacy for your loved ones after you're not there anymore. Trusts, wills, those are your tools to adequately plan for unfortunately death, and to leave a proper legacy for the people who you leave behind. We at Standard Trust often see situations where there's not proper planning, and the hardship it causes is real. And you won't be there to see it, but your loved ones will feel it. And by just taking a few steps while you still can, and exercising your right to determine what happens with your estate, will go a long way in ensuring that the whole process of death and grieving and the estate that needs to be administered after that is done in a proper and efficient manner.
So now, I think that's a very important point. How do we deal, or does your estate deal with your creditors and your debtors when you've moved on? And it mostly happens that when people pass away, the people who owe them disappear. And you may be owed million. And if your children or your spouse do not know, and that becomes a problem. And also the issue of the will, transparency in communicating where the will is, where the trust is. There are people who, they die without communicating with their loved one, and they passed on. The family does not know where to get that will, for instance, and to get that trust document. And it happens a lot of the time.
Well, a common misconception is that when I pass away, I no longer owe anyone any money. And that is completely wrong.
Yeah.
Your debts continue. Now, and those debts need to be settled. A very technical side of it is what grade or level of creditor those people are. So, for example, the bank that lent you money for your house has security in the form of that house. If your estate does not settle that bond, they will take the house. And that is where you hear the horror stories about estates losing the house. It wasn't the executor, I assure you. It was the bank that took the house. Now, you asked a question around assets and transparency. some very practical steps that help us administer an estate quickly. Make sure your taxes are up to date. If they are not up to date, we cannot close your estate. Make sure at least 3 people know where your original will is. Make sure that if you have lent money to a friend over a good arrangement, a gentleman's arrangement, make sure you make a note of it somewhere. Because those things, you are not here anymore to tell us, I lent some money to this person. A lot of things are very visible to the executors, such as bank accounts, property. But if you cannot readily identify it by using your social security or identification number, put it into a file or make someone aware of it.
The thing is, you never think that you're gonna die. So, and you never think you need to keep that kind of record that I gave him R1 million, we shook hands, and he promised to pay end of the year. And so suddenly I die, and you know, it was handshake. Your view?
I cannot overemphasize the need to know where the will is. We've had instances where a person died, no one knew whether there was a will in place or not. Unfortunately, there's a law where there's no wills bank where everybody can
Deposit their will.
Correct. Unfortunately, you can go to an attorney, he will do a will for you, a perfect will for you. But if he closes the shop 2 years later, what happens to your will? Those are some of the problems that people are facing out there. To add more on the whole process of paying creditors and all those things, your heirs, in other words, your children, will not inherit your estate until all your creditors have been settled. That is the misconception that people have out there. You cannot pass, as an executor, you cannot finalize that estate without paying the creditors.
So how long can this process take of winding up the estate?
It varies. Simple estate, 6 months, it's finalized. If it's a complex estate, if it's an insolvent estate where there's no money involved, property needs to be sold in order to meet some of the debts. So it can take a longer
Which
process.
means your children get poorer after you are gone than they were when you were there.
Unfortunately, because the creditors must be paid. So all the assets that you've accumulated, if you did not make provision, going back to the financial advisor that I said you must sit with, all those assets will be wiped out of your estate to settle all the debts that you had.
We commonly say in our business, if there's no property, meaning physical house that needs to transfer, about 6 months to conclude the estate. If there is property, allow for about 8 months. If families start fighting, or things like e-tolls or TV licenses or taxes are not done, then how long that takes to resolve those will determine the length of time to.
So what happened to your children during this time? They are hanging.
They are hanging. They are hanging for money. There are certain discretions the executors can make to financially assist those children, but those discretions are very risky to the executor, and a whole set of conditions need to be met before we can maybe advance some money to the children.
So it becomes a very difficult time for the family if your affairs are not sorted out.
Absolutely, it's a very the administration of an estate is a complicated procedure, and it's always advisable to have a specialist appointed as your executor to make that process as simple and as less painless for your heirs. I cannot overstress the importance of a will because that will simplify the process going forward. Obviously, there is a very practical problem with the original will going missing or no one knowing where it is. We at Standard Trust have a safe custody facility specifically for that purpose, so that we know where a client of ours will is when he passes away. And yeah, again, consult a specialist. That is, for me, it's very important. Take the time to do it properly, and you'll save a lot of heartache for your heirs, potential heartache.
A consideration is we've stressed to consult a specialist is the cost of that specialist. Executors and trustees are not charities. They don't work for free. But in the same token, anything that's too cheap necessarily is not right. So while you're going through the process, be mindful of the cost of those specialists to wrap up your estate, to administer your trust. Ask them what they are, how they'll be charged, how they manage them, because these can have a serious impact on the net legacy that's left to your family.
Thank you very much. I think this was a very interesting topic. The emphasis is here. Please ensure you have a will, ensure you have a trust, ensure if you need one, but ensure you consult a specialist to help you and guide you through this process so that you do not leave your loved one vulnerable or desperate after you've passed on. We'd like to thank our specialists on the show, Alex, Thabiso, and Leon. Thank you very much for giving us the insights about how we can go about sorting out our affairs. To you, the viewers at home, we thank you very much for tuning in. If you have questions or input, you can visit our website, www.globalbusinessroundtable.com. Remember at all times to seek ye first the kingdom of God and his righteousness, and all these things shall be added unto you. Matthew 6, verse 33. See you again next time. God bless and goodbye.